This is the second in our series of seminars devoted to navigating the COVID-19 pandemic. Tomorrow's seminar, which is at the same time, will address global tax implications. Your panel comprises lawyers from throughout our US offices. Tracy High, Annie Ostrager, and Ted Rogers are members of our labor employment group in New York, and David Spitzer is a New York member of our tax group. Julie Jordan is a labor and employment partner in Washington, D.C., and Dan McGimsey is a partner in that group in Los Angeles. Oh dear. I believe our slides are correct now. Sorry about that. In response to the new coronavirus, governments at all levels in the US have taken steps that have built over time and are only partially coordinated with each other and with pre-existing law. As a result, there are layers of requirements and potentially missed opportunities for employers at this time. We'll address these in the following order. First, considerations for businesses contemplating a temporary or permanent workforce restructuring. Second, considerations for employers evaluating assistance to the small bank forgivable loan program or through programs for mid-sized businesses. Third, considerations for businesses that are currently continuing to operate. And finally, we will discuss some ways in which the business restructuring and new leave requirements interact together. We are speaking from abbreviated materials that are on your screen. The more detailed materials have been emailed to you. In the middle of our presentation, I'll be providing a code for those of you looking to receive continuing legal education credit for your participation. We have a lot to cover. Ted, I know you're chomping at the bit. So with that, please start us off with workforce restructuring.
All right. Thank you very much, Mark, and thank you for everyone for participating. We're all kind of learning about this Zoom stuff and remote talking together. I, for example, found the new foreground from Zoom, which puts a tie and coat on top of your pajamas. Dave and Mark didn't get that, but they'll learn, they'll catch on. So with respect to business restructuring, no responsible business executive relishes laying off productive employees, but sometimes the viability of the business requires it. Julie, in a few minutes, is going to speak about positive ways that the government has put in incentives for people to keep employees. And I'll review, though, some of the considerations, legal and otherwise, when that is not an option. The first thing I want to talk about are temporary reductions. There's no real difference in the legal significance of the terms furlough or layoff, but layoff can be a little bit ambiguous because I think many people usually think of it as a permanent termination. So we'll use furlough instead for the temporary aspect. With respect to the plant closing law, which I'll get into a little bit with respect to permanent layoffs, it really does not come into play so long as your furlough is going to be for less than 6 months. Now, what we are seeing is employers are giving employees who they are furloughing a notice with a prospective return date, obviously couched that it may change, but with also a statement that in all events, the employer expects that the layoff will be for less than 6 months in order to make clear that this is not a plant closing eligible termination, but rather just a temporary furlough. As to what to do with respect to the employees who are off temporarily, we'll get to the fact that they, as well as people who are permanently severed, are eligible for enhanced unemployment benefits. Also, we're seeing some employers taking steps to continue to pay medical benefits or to make medical benefits available for their furloughed employees. Some plans just allow for that anyway, even if someone is not active. Otherwise, there's a possibility of amending medical plans, and we've seen some employers who actually pay the employees' portion of the medical care during the furlough. David Spitzer will talk to the employee retention tax credit later, but it's worth noting here that it's not clear whether they're available for the benefits payments if no wages were being paid. Turning note, WARN Plant Closing Act at the federal level, as well as state plant closing statutes, need to be considered. Now, there is an exception which will presumably apply here, but nevertheless, you need to keep it in mind. Just generally, and the materials go into quite some detail about this, the Federal WARN Act provides that for employers of 100 or more employees, they will need to give 60 days notice of a termination if they are terminating 50 or more employees in connection with a plant closing or a closing of operations, or if they are closing or, terminating a third or more of their employees at a single site. Now, one of the exceptions to the WARN Act is unforeseeable business circumstances, also natural disaster, and then faltering company. Unforeseeable business circumstances certainly does seem to define what we're experiencing today. There isn't yet definitive guidance on whether the coronavirus problem is considered a business circumstance that's not reasonably foreseeable. But I think we can all agree that that's an extremely reasonable interpretation here. And I think employers can be can take comfort that they could use that exception. Nevertheless, if that exception applies, the employer is still required to give as much notice as practicable. And as this crisis goes on, that qualification may come into play. The state analogs in New York and California, which are particularly significant here, have some qualifications differences as to the amount of employees covered and the length of notice. Both now, though, also include an unforeseeable business circumstances caveat. California just it really didn't adopt one. The governor basically imposed one just recently as part of this circumstance. Now, layoff planning. One of the things that if you are going to be planning to either furlough people temporarily or lay them off, it's important, as the second bullet point here notes, to first get a list of the candidates for the action and then check them demographically, make sure that there isn't some unintended apparent disparity in the characteristics of the people who are being chosen. Messaging is important, both the messaging to the affected employees, but also to the workplace generally. And often we find employers who are doing layoffs or even temporary furloughs find it best to try to do them all at once or in a narrow time frame so that they can say to the rest of the workforce that everything's over, at least foreseeably. The top bullet here gets to an alternative to an involuntary layoff, which are voluntary separation programs. There are potential alternative means of lowering the headcount. However, they do take longer, and they also have to be voluntary, which means that if you make it available to a group of employees, you can't choose among them. So it's best when you have a group of employees where you need the headcount down, but you don't think it's particularly critical, that some people don't take it. So that's really, there's one more slide that relates to something we put together. Oh, I'm sorry, excuse me. The unemployment benefits, the new enhanced unemployment benefits. There are three categories of them. The first is for those who've already exhausted unemployment benefits at the state level, because unemployment compensation is a matter of state law. And this is a grant which extends unemployment compensation for an additional 13 weeks for anybody who has exhausted benefits. That will expire December 31. The second enhancement is that the federal law defines a large group of people affected by COVID in various ways. For example, people who are at home because their children are out of school, people who have a close relative who have COVID, people who themselves have COVID, people who've become heads of household because of a COVID death. This broad array of employees would not otherwise be eligible for unemployment. They now are and will be eligible for it up to 39 weeks, which is the state 26 weeks plus 13 weeks. That program too expires December 31. And then finally, the one that's most written about is the $600 per week supplement for all benefits recipients. That expires July 31. During the time period, if someone is eligible for that, assuming that they also would be getting unemployment at half their salary, it means that anyone who's making roughly $50,000 a year or less will be getting more in unemployment insurance than they do in their salary, which is just a useful solace if you do have to take action to lay people off at that level. Finally, we do have a post which is linked in the materials, which outlines different ways that an employer who really wants to help workers who've been furloughed or adversely affected by coronavirus. Some employers have 501c3 organizations that can be useful, or private foundations, or donor-advised funds. Also, there's a possibility of assisting in the solicitation of private donations. The only thing to be mindful of is direct payments by an employer to someone whom they've laid off could affect unemployment benefits, but it is worth keeping in mind. So that's the sort of involuntary aspect of it and the cutback of the workforce. And now I'll turn it over to Julie, who will talk about ways potentially that you can hold on to employees. Thank you.
Great, thanks very much, Ted. Today, I will focus on one of the most publicized aspects of the CARES Act, the Unprecedented Paycheck Protection Program, or PPP, for small businesses. As I'm sure most of you are aware, the CARES Act provides up to $349 billion in federally guaranteed loans to small businesses who certify that they require financial assistance to pay employees and maintain operations. These loans are capped at the lesser of $10 million or 2.5 times the business average monthly payroll costs during the year prior to the loan. It's important to note that in calculating the average payroll cost, there is a cap of $100,000 in salary per employee. So anything above that amount would not count toward your payroll costs. So these loans are generally available to businesses with fewer than 500 US employees. That includes your part-time, your full-time, and temporary employees, but it does not include independent contractors. The Treasury Department just issued last night updated guidance on this issue. Under that guidance, in terms of determining what your headcount is, they say you generally look at your prior 12 months or for the calendar year 2019 to determine your number of employees. I note that different rules apply to new and seasonal employers. It is also very important to note that under the SBA rules, in many cases, you would also need to include the employees of your affiliates. Entities may be considered affiliates based on certain specified factors such as stock ownership, overlapping management, and identity of interest. This is a very factual analysis. There are also other important exceptions to the under 500 employees requirement, including, for example, businesses in the hospitality industry and franchises, or that otherwise meet the SBA employee-based standard for the industry in which it operates. So now turning to the terms of the program. Under the statute, the loans under the program could be for up to 10 years, but Treasury has now stated that the loans will be for a 2-year period and at a 1% interest rate. The statute provides for deferment of principal and interest payments for at least 6 months. Significantly, the loan principal amount can be forgiven if the borrower retains employees without reducing their workforce or the workforce compensation level. The actual loan forgiveness amount is up to the amount spent on qualifying expenses during the 8-week period after the loan origination date. Those expenses are detailed in the material you're being provided with. The loans are non-recourse as long as the loan proceeds are used for authorized purposes. So as a result, you should track all your qualifying expenses and be prepared to provide that documentation to your lender. Now, turning to what happens under this program if you reduce your workforce or their compensation during the 8 weeks after loan origination. The loan forgiveness will be reduced if you decrease your full-time equivalent employee headcount. There is a provided calculation to determine the precise amount of that reduction. Also, if the borrower reduces salaries or wages by more than 25% for any employee that made less than $100,000 in 2019, loan forgiveness also will be reduced by that amount over the 25% reduction. Most significantly, there is a rehiring savings clause by which employers can reverse prior termination or furlough decisions if they do so by June 30th of this year. If they do that, you can avoid the corresponding loan forgiveness reduction. With that, I'm going to turn it over to David to provide his views from a tax perspective.
Thank you. So the CARES Act has a number of tax-related relief provisions. I'm going to talk about two specifically that are particularly related to the issues that we've been discussing. First is the delayed deferment, the delayed payment or the deferral of the employer payroll taxes, and then I will talk about the retention tax credit. For 2020 payroll taxes, and here specifically we're talking about the employer portion of the Social Security tax, any amount accruing after March 27th, 2020, which would otherwise be required to be deposited with the IRS, is deferred. 50% is not required to be deposited until December 2021, and the other 50% is not required to be deposited until December 2022. Importantly, if any taxpayer has taken out an SBA loan under the Paycheck Protection Program, which loan is forgiven, that taxpayer is not eligible to defer or delay payments in these payroll taxes. Interestingly, this rule for denying the ability to defer the payroll tax works slightly differently than the similar provision with respect to the retention tax credit. Again, only if you're denied this benefit, only if the loan is forgiven, although presumably most of these loans are going to be forgiven, and the denial is only to the taxpayer that has taken out the loan and has had the loan forgiven, as opposed to any affiliates of that taxpayer. We'll get to that in a moment and see how it's different with the retention tax credit. For the retention tax credit, if an employer is eligible, the amount of the credit is equal to 50% of the qualified wages paid between March 12, 2020 and the end of the year. The maximum amount of wages that's permitted to be taken into account for this purpose is $10,000, which means that the maximum credit is $5,000 per employee. Mark, there you go. Thank you. So who is eligible to get the retention tax credit? First, there are two tests in the alternative. First is an employer must have undergone a full or partial suspension of their business due to the order of a relevant government authority. What exactly that means is a little bit open to interpretation. Not always clear what it means to have a partial suspension of business. The Senate Finance Committee on their website has a Q&A which suggests that they intended that the credit be available to cover employees who are only available to work on a reduced hourly basis, and that the credit would then be available in proportion to their reduction in hours. But we're awaiting further guidance on what some of these terms mean and how these will be applied. In the alternative, an employer is also able to take advantage of the credit if they've experienced a 50% year-over-year decline in gross receipts. If an employer has taken a loan under the Paycheck Protection Program, however, they're not eligible to take the tax credit. One important point here is that there are affiliation rules that will kind of aggregate multiple commonly controlled companies and treat them as a single employer. That will apply. Well, what that could mean is that if one affiliate has taken out an SBA loan under the Paycheck Protection Program, it could disqualify all of its affiliates from being able to take the tax credit. So in certain circumstances, it will be important to consider whether an employer that is looking to take the loan could invalidate the credit of other companies as well. What constitutes, going back to calculating credit, what constitutes qualified wages? What wages can be taken into account? It depends in part on how large the employer is. If the employer, and again here, this is taking into account all commonly controlled companies. If the employer has more than 100 employees, then only amounts paid to the employee for for periods when the employee is not working, or as I've mentioned earlier, is working on a reduced basis, only those wages can be taken into account. If an employer has less than 100 employees, any amounts paid to employees can be taken into account. Qualified wages also includes the allocable portion of qualified health benefits that are paid for the employee's behalf. Again, it's all taken into account, subject to the $10,000 per employee cap. But for employees with lower salary levels, the health benefits could be taken into account towards a $10,000 cap. The employee retention credit is refundable. The IRS has already released a form that would allow employers to claim the credit. Some of the mechanics for claiming the credit are still being worked out. And back to you.
Thank you, David. So now address financial assistance to mid-sized businesses. And in this regard, I will be fairly brief, given we are still awaiting guidance in the application procedure from Treasury for this program. In short, the CARES Act authorizes the Secretary of Treasury to implement a financial assistance program targeted at mid-sized businesses with 500 to 10,000 employees. So that's for mid-sized businesses with between 500 and 10,000 employees. Unlike the Payment Protection Program, this program does not have any mechanism for the forgiveness of the loans. That being said, there are important employment considerations for mid-sized companies who are considering receiving financial assistance under this program once its details are announced. First, there are restrictions on executive compensation on a going forward basis for employees who earn more than $425,000, as well as differing limitations on those executives who earn over $3 million in total compensation in 2019. There are also limits on severance packages that bear consideration. The details on these restrictions are set forth in the provided material. I do note that the total compensation in determining whether these thresholds are met is quite broad, and it includes salary, bonuses, stock awards, and any other financial benefits. Importantly, to receive a loan under this program, a borrower will have to certify, among other things, that it will retain 90% of its workforce at full compensation and benefits. There will be no stock dividend or buyback for a year, except to the extent required under a pre-existing contract. And during the term of the loan and for a 2-year period after repayment, the borrower also agrees to not outsource or offshore jobs or abrogate a collective bargaining agreement. Finally, a borrower will remain neutral or stay on the sidelines in any union organizing effort for the entire term of the loan. With that, I'm going to turn it over to Annie to address our next topic.
Thank you, Julie and Dave. We're going to switch gears now a little bit, and Diane and I are going to talk about considerations for businesses as they continue to operate and in some instances have certain employees report in person to the workplace. Due to the COVID-19 crisis, the majority of states have issued orders instructing its residents to stay home and prohibiting non-essential businesses from having employees report to the workplace in person. This situation is, of course, fluid, and more states are issuing and modifying their stay-at-home orders. As of today, the federal government hasn't waded into this to enact that kind of mandate, and there are variations from state to state as to what's required. And this means that neighboring states with overlapping metropolitan areas may have different parameters to their guidance. To comply with state orders, employers need to determine whether their business is an essential or critical one. So in making this determination, employers should consult the applicable state executive orders and state interpretive guidance. Employers should also be aware that certain localities are issuing their own guidance that can be more restrictive than what the state has in place. California is an example of such a state where numerous counties have issued their own more restrictive stay-at-home orders. There's also some advisory guidance from the Federal Cybersecurity and Infrastructure Security Agency within the Department of Homeland Security that may be helpful for employers as they make determinations as to whether a business qualifies as essential. Employers should also keep in mind that most states' guidance allows only essential or critical parts of the business to remain open. So if a manufacturer makes medical equipment and toys, only the business line devoted to medical equipment can stay open and continue to have workers report in person. Some states, such as New York, have released guidance explaining that non-essential businesses can permit a single employee to report in person for the purpose of performing a specific task that has to be done in person, like collecting mail, as long as that employee will not be in contact with other people. If a business isn't explicitly covered by state guidance, in many states, that employer can seek from the state a designation as an essential business. In New York, for example, businesses can seek designation as essential, but only if they're not covered. Regardless of whether an employer's business is clearly covered, it's prudent for a business to record the rationale for its determination in case it's ever challenged in the future. If a business determines that it meets the criteria to be deemed essential, it still then has to determine which employees may report in person. In so doing, employers should bear in mind that many states are encouraging and some are requiring even essential businesses to utilize telecommuting to the maximum extent possible. Once a business determines which workers may continue to report in person, it should make sure that recommendations from the CDC and other federal, state, and local agencies are being followed. Essential businesses may also wish to consider providing safe passage letters to those employees who will continue to report in person. And similarly, they may want to draft comfort letters for suppliers and vendors on which they rely for essential services. Not all states have issued guidance that expressly exempts suppliers and vendors, but it makes sense that essential businesses require those types of supports to remain in place. Employers need to be aware of potential consequences for non-compliance with state stay-at-home orders. First, some states have implemented penalties that range from civil fines, business closure, to loss of a business license, and even imprisonment. Second, employers may want to consider that employees who disagree with their employer's assessment can file complaints with the state or seek redress through the press. And it's not just employees who may alert the press. If a competitor has reached a different opinion regarding the essential determination of their employers, then they may alert the media. Even customers or clients may report businesses that they do not believe are complying with stay-at-home orders. As in all aspects of this crisis, the guidance on all this is evolving, so employers are encouraged to regularly consult with local, state, and federal laws. And you can hear more about this on the podcast that Julie and I recorded on this subject. I will turn now to the Fair Labor Standards Act, and I won't go into detail, but will flag that even in the midst of this crisis, obligations under the FLSA still apply. This means, in a nutshell, that employers are required to pay non-exempt employees only for the hours those employees have actually worked, including remote work, and not for the hours that those employees would have worked under normal circumstances. Employers are also required to maintain records of the hours worked by their employees, including those who are teleworking. To avoid record-keeping issues, employers may want to consider implementing procedures for tracking non-exempt employees' remote work, such as implementing a virtual clock in and out system or scheduling standing video conferences or phone calls. Employers may also want to clearly communicate any overtime limitations. For exempt employees, employers must pay salaried employees their full salary in any week in which they perform any work. This means that if an exempt employee only does a few hours of work in any given week, an employer is still obligated to pay that employee his or her full weekly salary, subject to limited exceptions. With respect to the FLSA, one last point, employers may be receiving requests regarding technology and equipment and other tools that employees need to work from home. Employers cannot require an employee to pay for or reimburse the company for business expenses, where doing so would reduce non-exempt employees' earnings below the required minimum wage and overtime compensation, or below an exempt employee's guaranteed salary. Although the guidance isn't clear as to what exactly will be reimbursed, employers probably need to reimburse employees for expenses that are reasonable and necessary to teleworking, and not for expenses that are solely for their employees' comfort. This means employers need to provide their employees with the technology needed to telework, such as, for example, a computer. And now I'm going to turn it over to Diane.
Thanks, Annie. I'm going to talk first about the ADA, but before I do that, I just want to add one point on top of what Annie just noted. If you are a California company, you also need to be aware of the California Labor Code provision, which also has reimbursement requirements for people that are telecommuting or incurring other business-related expenses. So in addition to making sure that you're reimbursing expenses in compliance with the FLSA, you should also be aware of the California Labor Code and the interpretation of that provision. And on to the ADA. So the EEOC has released some guidance on how the ADA may be implicated by COVID-19, but it's important to note that the guidance is being given in the context of this current public health crisis. once we get to a point where COVID-19 doesn't pose the same risks as it does today, the EEOC expects that it may revise its guidance, and some of what I'm about to tell you may change. As to the fundamental question of whether COVID-19 is a disability under the ADA, unfortunately, the current answer from the EEOC is we don't know yet. The EEOC has acknowledged, however, that COVID-19 is a direct threat under the ADA, which means that employers are permitted to take certain steps to protect their workforces from the spread of COVID-19, which means, for example, employers may bar infected individuals or those with symptoms of COVID-19 from entering the workplace, or may send those individuals home. Employers are also allowed to ask all employees who are physically entering the workplace questions to determine if they have or may have COVID-19. One question that's come up is whether an employer may single out a particular employee or employees to ask questions to. And the answer is, in some circumstances, yes. But to single out a particular employee for questioning, the employer has to have a reasonable belief based on objective evidence that the person may have the disease. So, for example, if an employee has a persistent hacking cough, the employer can ask about the cough, whether the employee has been to a doctor, or whether he or she knows if they have COVID-19. But the employer needs to make sure there are specific symptoms relating to COVID-19 before questioning the employee in a manner that's different from how other employees are being questioned. Also, one other thing to note is that employers should not be asking these questions to any employees who are telecommuting, because they're not physically entering the office or interacting with coworkers. Another related question is whether an employer can ask an employee who's physically coming into the workplace whether they have family members who have COVID-19 or family members who are experiencing any symptoms associated with COVID-19. There, the answer is no, not in that way at least. The Genetic Information Non-Discrimination Act prohibits employers from asking medical questions about an employee's family members. But an employee can get to the same place without implicating privacy concerns by asking more generically whether an employee has had contact with anyone who the employee knows has the disease or symptoms associated with the disease. Another ADA compliance issue that employers need to keep in mind is the need to keep confidential employees' medical information, including the identity of any employee that contracts the disease. This is obviously a big area of concern, as employers want to take steps to ensure that the disease is not spread around the workplace. But even where the goal is to protect other employees, an employer still cannot identify the infected employee by name. Instead, the EEOC has suggested that the employer interview the infected employee to get a list of people with whom the employee may have had contact through the workplace, and then notify those individuals that they may have come in contact with an infected person, but always being mindful of not identifying who the infected person is. Because the need to address this type of issue usually comes up in a sort of emergency situation, if you haven't already done so, it's a good idea to take steps now to identify who that person will be, who will conduct the interviews, and also will be carrying out the notifications to other potentially impacted employees, and to set some clear parameters around those discussions in advance so that all of this can be done promptly when an issue comes up. Another important ADA-related question is whether infected employees must be granted reasonable accommodations. Because it's currently unclear whether coronavirus is a disability under the ADA, it's also unclear whether employers are obligated to grant reasonable accommodations to employees who are infected with coronavirus. But assuming that the question is ultimately answered in the affirmative, the next question is whether employers will need to provide accommodations to employees who aren't infected, but who fall into the CDC's at-risk categories, such as older adults, pregnant women, and employees with certain pre-existing disabilities. The EEOC has addressed this question and indicated that employers shouldn't treat all employees the same way in determining workplace arrangements to prevent the spread of the virus, and are not required to grant an accommodation to an employee simply due to his or her age, for example. The same is true with respect to pregnant women, as pregnancy itself is not considered an ADA disability. However, where an employee has a disability that puts him or her at greater risk of a severe illness, if he or she contracts COVID-19, such as chronic lung disease or a serious heart condition, that employee may request reasonable accommodations from the employer. Next slide. And I apologize for the background noise if you're hearing it. It's apparently trash collection day here. So next, we're going to talk briefly about the leave provisions of the Families First Coronavirus Response Act, the Emergency Family and Medical Leave Expansion Act, and the Emergency Paid Sick Leave Act. So the Families First Act's leave provisions apply to private employers with fewer than 500 employees and all public agencies and entities with at least one employee. Although one note for small businesses with fewer than 50 employees, you may qualify for some exemptions. Before getting into the specifics of the Act, I want to touch on the Department of Labor's guidance as to how and when an employer determines if they have fewer than 500 employees as defined in the Act. The relevant date for the employee count is the date the employee seeks leave. And as to who counts as an employee, obviously full and part-time employees count towards the 500. And if you're a joint employer under the Fair Labor Standards Act, all joint employees count as well. You do not need to count independent contractors or workers who've been laid off or furloughed and have not subsequently been reemployed. Now on to some of the particulars of the acts. Next slide. I'll start with the Emergency Medical Leave Expansion Act, which is a temporary expansion of the existing Family and Medical Leave Act. Under the Expansion Act, an employee is eligible for leave if the employee has been employed by the employer for at least 30 calendar days. Although the CARES Act has expanded this to include employees who were laid off after March 1st, 2020, and then subsequently rehired by the employer, so long as the employee had worked for the employer for at least 30 of the last 60 calendar days prior to the layoff. A covered employer must provide an eligible employee with up to 12 weeks of leave if the employee is unable to work or telework because of a need to care for a son or daughter due to school closures or unavailability of child care providers due to COVID-19 related reasons. The first two weeks of the employee's leave is permitted to be unpaid. But after the initial 2 weeks, employers must pay employees at 2/3 of the employee's regular rate of pay based upon the number of hours the employee would normally work. The Expansion Act also provides some job protections to employees, and subject to limited exceptions. When an eligible employee returns from leave, an employer must restore the employee to the position that they held when the leave began, or to an equivalent position in terms of pay and other terms and conditions of employment, such as benefits. Another side note for employers here with fewer than 25 employees, you may be exempt from the job protection requirements if certain requirements are met. And next, briefly, I'll talk about the Emergency Paid Sick Leave Act. The Paid Sick Leave Act is the first ever federal paid sick time mandate. The act, which covers all employees regardless of how long they have been employed, entitles full-time employees with 2 weeks or up to 80 hours of paid sick leave wages, and part-time employees are entitled to paid sick leave wages for the average number of hours that they work over a 2-week period. There are 2 types of leave under the act, each of which has different pay requirements. First, an employer must provide paid sick leave for self-care at an employer's regular rate of pay if the employee is unable to work or telework due to specified COVID-19 related reasons, which I won't go through since you have them here on the slides. Second, an employer must provide paid sick leave to care for a family member if an employee is unable to work or telework because of certain COVID-19 related reasons. One last point to be mindful of on the leave, as to all of the paid leaves that I just discussed, there are daily and aggregate caps on the amounts that need to be paid. And employers also need to consider how these leave policies interact with other applicable leaves, such as traditional FMLA leave or other employer leave policies. And for that, I'm going to turn it over to Tracy.
Before we go to Tracy, however, it's time for your CLE code. So I'll give you 2 seconds to find a pen or a pencil, and that code is 871104. 871104. Sorry to interrupt. Back to you, Tracy.
No problem, Mark, and thanks, Annie and Diane. We're getting close to the end here, but before we conclude, we want to briefly address how certain of the leave provisions interact with some of the business restructuring decisions employers are considering, as well as with employers' existing leave policies. Last week, the Department of Labor's Wage and Hour Division provided some guidance on these and other topics. I'll note, though, of course, since the Families First Act is very new, relevant guidance is still being issued and updated. DOL posted its temporary rule implementing regulations last Wednesday on April 1st. That very same day, 2 members of Congress sent a letter to the Secretary of Labor challenging some of that guidance by arguing that the guidance contradicts the plain language of the Act and violates congressional intent. As relevant to the topics I'm addressing, the letter argues that the DOL is allowing employers to cut off employees' rights to leave under the Act. Now, it remains to be seen how, if at all, the DOL's guidance or implementing regulations will change in response to this letter, but this is just one example of why, as we've discussed throughout this presentation, it's really critical for employers to continue to monitor these issues to ensure that they continue to act in accordance with the most up-to-date advice. But for now, let's take a look at where things stand currently. With respect to worksite closures, timing is a key consideration when assessing the interaction between closures and employee leave benefits. Under the DOL's current guidance, if an employer closes an employee's worksite at any time before the employee takes leave, an employer is not required by the Act to provide paid leave to that employee. This is true even if the employee requested leave before the closure or the employer plans to reopen the worksite in the future. And that's regardless of the reason the worksite closed. Does not matter for this purpose whether the worksite closed due to lack of business or because of a federal, state, or local directive. If an employer closes an employee's worksite while the employee is on paid leave under the Families First Act, the employer must pay the employee for any leave used before the closure, but is not required by the Act to provide paid leave after the closure. Even if a worksite stays open, businesses may choose to furlough employees. If an employer furloughs an employee for lack of work or business, current guidance provides that the employer is not required by the Act to provide paid leave to a furloughed employee. Alternatively, employers may decide that they need to reduce their employees' work hours. An employer who reduces an employee's work hours is generally not required by the Act to provide paid leave to that employee for the hours the employee is no longer scheduled to work. However, it's important to note that if a COVID-19 qualifying reason prevents the employee from working the reduced schedule, then the employer is required by the Act to provide paid leave to that employee. There may be some instances in which an employee can take intermittent leave, and we'll talk about that in just a bit. Employers should keep in mind, and Ted noted this previously, the prohibitions on workplace discrimination and harassment based on age, sex, race, and other protected classes, and make sure that they are applying their policies and implementing new practices and any workplace restructuring in a neutral and non-discriminatory manner. Ted covered the employment benefits available under the CARES Act, so I'll just note that worksite closures, furloughs, or even reduced work hours may mean employees are entitled to employment benefits under the CARES Act or state law. Note, however, that if an employee is on leave under the Families First Act, the employee cannot also collect unemployment benefits. Let's now talk about the interaction of leave provisions. If an employee is eligible for leave under both the Sick Leave Act and Expansion Act to care for a son or daughter due to school closures or care unavailability, the employee is entitled to a total of 12 weeks of paid leave. For the first 2 weeks, an employee will receive paid leave at 2/3 pay under the Sick Leave Act. In other words, this paid sick leave covers the otherwise unpaid leave under the Expansion Act. An employee will then receive at least 2/3 pay under the Expansion Act for the remaining time off. Whether an employee can take leave intermittently depends on the type of leave, and intermittent leave is allowed only with employer permission. Leave may be taken intermittently if the employee teleworks, regardless of whether the employee is taking leave under the Expansion Act or the Sick Leave Act. If an employer permits, an employee who is teleworking may also take intermittent leave, regardless of which of the COVID-19 qualifying reasons, which Diane described earlier, as noted on the slide, is the basis for the employee's leave under the Sick Leave Act. An employee who reports to a work site may take intermittent leave only to care for a son or daughter whose school is closed or care provider is unavailable. Note that the entitlement to leave ends once the employee no longer has a qualifying reason for leave, for example, because a child's school reopens or a co-parent can care for the child. Intermittent leave is not permitted if an employee must report to a work site and is taking the leave for a reason other than to care for a son or daughter due to school closures or unavailability of work. In other words, if the employee is infected or may be infected. Under such circumstances, an employee must continue to take paid sick leave each day until either he or she uses the full amount of paid sick leave or no longer has a qualifying reason for the leave. If an employee no longer has a qualifying reason before exhausting his or her entitlement to paid sick leave, then the employee may take the remaining leave at a later time before December 31st, 2020, if there is a qualifying reason. Employers who are trying to understand their responsibilities under the Families First Act are likely to wonder how pre-existing leave policies and entitlements come into play. Note that, as I mentioned earlier, guidance here is developing, and some of the DOL's guidance may appear in conflict with the language of the Families First Act and with other guidance. But for now, we're going to discuss it as it stands, and as I noted earlier, it's important to monitor this space. As discussed earlier in the presentation, the Sick Leave Act provides for up to 2 weeks or up to 80 hours of paid sick leave. Leave for self-care is paid at the employee's regular wages, but leave to care for others or under the catch-all is paid at 2/3 the employee's regular wages. This leave is in addition to the employer's pre-existing leave policies or any collective bargaining agreement that applies, as well as any other leave provided under federal, state, or local law, including FMLA leave. If an employer and employee agree, an employee may supplement paid sick leave, paid at 2/3 wages, with accrued leave under the employer's pre-existing leave policies to an amount up to the employee's normal earnings, but an employer cannot require an employee to do so. And now turning to the Expansion Act, under the Act, an employee is entitled to up to 12 weeks of childcare, with the first 2 weeks being unpaid and the last 10 weeks being at 2/3 pay. Current DOL guidance is unclear whether an employer may require an employee to use Expansion Act leave concurrently with accrued leave under the employer's existing policies. Regardless of how much employer-provided leave an employee has taken prior to April 1, the employer must permit the employee to take any and all expanded family and medical leave to which he or she is entitled. Note, however, that an employee who has already used all or a portion of his or her 12 weeks of leave under the FMLA during the current period is able to use only the remaining weeks, if any, for Expansion Act leave. So, for an example, an employee who previously used 6 weeks of traditional FMLA leave is entitled to only 6 weeks of Expansion Act leave. And with that, Mark, I'll turn it over to you.
Thank you very much. It looks like unexpectedly we have a couple of extra minutes left, and I think it would make sense to use them if that's all right with folks. So we have a couple of questions that we've collected that I thought I would run by the panel. The first one relates to how to access unemployment benefits under the CARES Act. And in particular, is there anything employers need to do to allow employees to access these extra benefits?
Fundamentally not. The employer, of course, can refer its employees to the state unemployment offices, but each state runs its own unemployment compensation system. They have websites up, they have pretty easy to understand instructions, and they're getting more digital as time goes on. So other than a referral, there really isn't anything that an employer fundamentally has to do.
For people who are still working, as a result of having limited people be able to access the workplace or willing to access the workplace, I think some employers are thinking about changing responsibilities or adding responsibilities. Is there a limit to employers doing that in the current circumstance?
Mark, that's allowed under the Fair Labor Standards Act, and employers can do that, and it's expected that that is going to happen given the constraints on who's permitted to report in person. But the best thing for employers to consider doing would be to have clear communication with their employees about that potential.
Another question that's come up relates to maintaining current medical information while people are working from home, and any steps that employers should or could take to protect employee medical information confidentiality while working from home and perhaps not accessing the regular system. I was hoping that, oh, good.
I can take that one, Mark. The EOC has actually issued very specific guidance on this point, and they've made it absolutely clear that you are still required to comply with all the relevant privacy rules protecting employees' medical information. In accordance with those rules, you should be maintaining that information separate from the personnel file, and you should be trying to the extent possible, following your standard procedures in place for medical documentation. They recognize that in light of the current environment, many folk are teleworking, so they recognize you might not be able to follow it exactly as you did before, but you should try to the greatest extent possible.
Thank you very, very much. I think that concludes our webinar today. We very much appreciate it. We hope you found it useful. There are links at the end of the materials that you have. We encourage you to subscribe to our blog, Legal Developments Affecting the Workplace, and we have a variety of detailed memoranda on this topic at www.solcrom.com under Coronavirus S&C Update. Again, there are links there. As I mentioned, tomorrow's seminar covers global tax implications, and we currently plan to host additional seminars on crisis management litigation, mergers and acquisitions, finance and restructuring, and capital markets. Thank you for joining us, and be well.